Hi everyone. So today's session we're going to do is on company law. My name is Shazia Khan, and the learning outcome we'll be doing is learning outcome 3, which is to understand the rights of shareholders and minority shareholders. I just want to give you a summary of the last session we did, which was learning outcome 2. In that session, we looked at understanding the rights and obligation of directors. We looked at directors' duties. In 2.1, looked at the legal nature, the roles and powers and liabilities of shareholders and directors towards companies. So we looked at the legal nature, the roles of shareholders in regards to within a company, what they did. We also went on to look at their powers and their liabilities within a company. We then went on to look at the legal nature, roles and responsibilities and liabilities of directors, and how they have several roles within a company, things like overseeing the company's operation. They represent the company's dealings with third parties, customers, suppliers, regulators, and shareholders. We then went on to look at the director's powers and what liabilities stand with them. We then went on to 2.2, which was assessing the consequences of breach of directors' duties in company law. We looked at the legal consequences. So personal liability, which is directors who breach their duties may be held personally liable for any loss incurred by the company or its stakeholders as a result of their actions. We looked at the fiduciary duty breach, which was breaching any sort of duty, which is a duty of loyalty, care, and good faith. We then went on to look at the disqualification. So in serious cases of misconduct or negligence, directors may face disqualification from serving as directors or any company for a specified period. We also looked at the criminal sanctions of directors. So the ones directors who engage in things like fraudulent, dishonesty, or any sort of criminal conduct must be subject to any sort of criminal prosecution under company law. And it could be either sanctions could be a fine or imprisonment. Penalties imposed by the courts for offences such as could be fraud, theft, or false accounting. We then went on to look at the financial consequences. So there's financial penalties, which directors are found liable for breaching their duties, may have to be required to pay any sort of monetary fines, penalties, or damages to compensate its company or the stakeholders in regards to what they've lost. We also looked at loss of assets. So directors may be required to return improper gains or benefits obtained through the breach of duties, such as any sort of secret emissions or diverted opportunities. We then went on to look at reputational consequences, so damage to the reputation, any sort of professional reputation and credibility, and loss of trust, so any sort of stakeholders, shareholders, employees, suppliers, regulators may lose their trust and confidence in the directors and the company. We then went on to 2.3, which looked at analysing the director's responsibility to creditors of the company in the financial distress. So we looked at the fiduciary duties, where directors owe a fiduciary duty to act in the best interests of the company, and the duty of care and skill, which is directors must exercise reasonable care, skill, and diligence in managing the company affairs. And we looked at the financial distress as well. We then went to look at the preferential treatment prohibition and avoidance of wrongful trading, and the duty to consider creditors' interests. So directors must consider the potential impact of the decision on creditors' interest. Excuse me. We then went on to look at the insolvency proceedings. So if a company becomes insolvent or is at risk of insolvency, directors have the duty to take appropriate action to protect their creditors' interest. And then we looked at the avoidance of fraudulent transaction. So directors must refrain from engaging in any fraudulent or preferential transaction that may prejudice the creditor's rights or unfairly advantage any sort of stakeholders. We then went on to look at 2.4, which was to analyse the mechanism for disqualification of directors. So we looked at the statutory disqualification in the UK, which is they would be statutorily disqualified on grounds such as breach of fiduciary duties or any other legal obligations, any sort of wrongful trading or fraudulent conduct, any sort of persistent failures to comply with legal requirements such as filing accounts or paying taxes, or conviction for certain criminal offences relating to company law or corporate governance. We went to look at voluntary disqualifications. So this is where directors may voluntarily resign or agree to be disqualified from serving as a director if they acknowledge their misconduct or unfitness for the role. And this sometimes may occur as part of a settlement agreement with the regulatory authorities, and also automatic disqualification. So in some jurisdictions, they have provisions for automatic disqualification of directors in certain circumstances. For example, in the UK, directors will be automatically disqualified if they're declared bankrupt or are subject to certain legal restrictions. We then went on to look at the civil penalties, finally, and the sanctions. So sanctions of misconduct, compensation orders, any sort of restrictions to act as a director in the future. We looked at the civil penalties insured by the financial regulators or corporate watchdog. We then looked at the period of disqualification as well, which may typically specify if they got disqualified, how long they would be disqualified for because of the severity of the misconduct and the nature of the offence. So disqualification may range from a few years to indefinite or permanent disqualification, bringing individuals from serving as directors for life. So that was learning outcome 2. Now we're moving on to learning outcome 3, which looks at understanding the rights of shareholders and minority shareholders. So the indicative content here is that we'll be looking at member voting rights, classification of shares, variation of rights, shareholders, minority shareholder protection. We have a video here as well, which looks at, so you can look at in your own time, on shareholders and directors' rights and their roles and responsibilities. So we look at firstly at 3.1, which looks at analysing the rights of shareholders in public and private limited companies. So analysing the rights of shareholders in public and private companies involves understanding the differences in their rights and privileges. Here is an analysis of rights of shareholders in public limited companies. So they have transferability of shares. So shareholders in public limited companies typically have greater flexibility in transferring their shares. Shares are freely transferable, allowing shareholders to buy and sell them on public stock exchange without restrictions imposed by the company. Liquidity of investments. So public company shareholders benefit from greater liquidity of their investment. They can easily buy or sell shares on the stock market, providing them with the ability to exit their investment quickly if desired. Voting rights. So shareholders in public limited companies have the right to vote on key corporate matters, including the election of directors, approval of major transactions, amendments to the company's articles of association, and other significant decisions. Voting rights are typically proportional to the number of shares held. Access to information. Public company shareholders have access to extensive information about the company, including financial reports, annual accounts, regulatory filings, and other disclosures required by securities regulators. This transparency enables shareholders to make informed investment decisions. Then we have dividend rights. Shareholders in public limited companies are entitled to receive dividends declared by the company's board of directors. Dividends are typically distributed based on the company's profitability and dividend policy, subject to any sort of approval by shareholders. The payment of the right to receive dividends is one of the most significant financial benefits of being a shareholder. The payment of dividends is not automatic, though it depends on the company's profitability and decision of the board of directors. Then we go on to the rights of shareholders in private limited companies. So the transfer of restrictions. So shareholders in private limited companies may face restrictions on the transfer of their shares. These restrictions which are often outlined in companies' articles of associations or shareholder agreements, may include preemption rights, rights of first refusal, rights of preemption, or approval requirements for share transfers. Limited liquidity. So shares in private limited companies are less liquid compared to those in public companies. Shareholders may find it challenging to sell their shares as there is no public market for trading, and transactions may be subject to approval by other shareholders or other companies' board of directors. Voting rights. So shareholders in private limited companies still have voting rights, but the extent of these rights may vary. In the closely held private companies, voting rights may be concentrated among a small group of shareholders or subject to special voting arrangements, such as weighted voting or unanimous consent requirements. Limited access to information. So private company shareholders may have limited access to information compared to their public company counterparts. While shareholders are entitled to certain disclosures under company law, private law companies are generally subject to less stringent reporting and disclosure requirements. Dividend policy. Dividend distributions in private limited companies are determined by the company's management and shareholders. Company's financial dividend payments may be more discretionary and subject to the company's financial performance, cash flow needs, and growth objectives. In summary, shareholders in public and private companies enjoy similar fundamental rights, such as voting rights, dividend rights, and access to information. However, there are differences in the transferability of information, of shares, liquidity of investment, and governance structures between public and private companies, which can impact the exercise of shareholders' rights and their investment experience. As a shareholder in a limited company, whether private or public, you have certain basic rights. As I've just mentioned, some rights include things like, shareholders can exercise independent judgment. And as an investor within a limited company, you are provided with certain protection known as shareholders' rights. These protections may vary according to whether you have hold ordinary shares or preference shares in the company. Preference shares usually give their holder preferential rights in relation to dividend payments, as we mentioned earlier, and unwinding up of the company, but carry limited voting rights. These legal provisions allow shareholders to exercise control over the company to some extent. For instance, shareholders may be entitled to vote on substantial company decisions, and the Companies Act 2006 is the primary source of these rights in England and Wales. A company's articles of association, as I mentioned earlier, a memorandum of association, and any shareholder agreement can further define or limit its right. So, as a shareholder, a shareholders' agreement is a private contract between the company's shareholders. It usually outlines their rights, as we mentioned earlier, and it looks at the obligations of shareholders together with providing procedures for resolving any sort of disputes or making changes to the company's structure. This is often includes voting rights applying to holders of different classes of share and the right to information about the company specific to each shareholder. And we'll be looking at the voting rights a little bit next, hopefully. This can offer an additional layer of protection to shareholders who are not directors of the company. While it isn't legally mandatory, a well-drafted shareholders agreement can prevent future disputes by providing clarity. It allows shareholders to customize their rights and obligations to suit their specific needs and circumstances beyond what is provided in the Companies Act 2006 and the company's articles of association. So you can, customize it as the way you want to. So now we're going to go on to looking at explaining 3.2, explaining the rights of members in voting. So you have general voting rights. And voting rights in a limited company are the rights of shareholders to vote on certain company matters that are beyond the scope of the directors' decision makers. So we have general voting rights, which are members of both public and private limited companies have their fundamental right to vote on significant matters affecting the company. These matters typically include the election of directors, approval of financial statements, the appointment of auditors, amendments to the Articles of Association, any mergers, acquisitions, and any other corporate decision that are quite major. Each member typically has one vote per share, although the company's Articles of Association may specify different voting rights for different classes of share. Ordinary resolution number 2. Members voting are exercised through resolutions passed at general meetings of the company. Ordinary resolutions require simply a majority of votes cast by members present or represented by proxy at the meeting to pass. A simple majority vote usually means that 50% of the votes are cast. Then you've got special resolutions. Certain decisions may require special resolution, which typically requires a higher threshold of votes to pass. Special resolutions usually require at least 75% of the votes cast by members present or represented by proxy at the meeting. Then we have number 4, which is proxy voting. Members may appoint proxies to attend and vote on their behalf at general meetings. This allows members who are unable to attend the meeting in person to still participate in the voting process. Proxy forms are provided by the company, and members must specify how they wish their votes to be cast on each resolution. Then you have electronic voting. So with the advancements in technology, companies may offer electronic voting options to their members. This allows members to cast their votes remotely, typically through an online platform or electronic voting system. Electronic voting enhances convenience and accessibility for members, especially for companies with a large number of shareholders or geographically dispersed shareholders. Number 6, the willing by show of hands versus poll. In general, meetings voting can be conducted either by a show of hands or by poll. A show of hands is the default method for a show of hands is the default method for voting, where each member present at the meeting has one vote. Resolutions are decided based on the majority of show of hands. However, if a poll is demanded by members holding at least 10% of the voting rights, each member's voting power is determined by the number of shares they hold. This ensures that larger shareholders have proportionality, greater influence in the outcome of the vote. Voting rights for shareholders are usually, as we mentioned, in proportion to the number of shares owned as percentage of the total issued and what is paid for as equity share capital of the company. Such shareholders are called equity shareholders and have right to vote attached to their shareholding. The voting rights attached to shares are usually voting rights at general company meetings. Voting at general meeting is typically decided by show of hands, as I've mentioned, one per shareholder, regardless of the number of share held. But this isn't for the case, in regards to how they proportionate the share, like 10% and 75%. In conclusion, so in summary, members of the both public and private limited companies have rights to vote on important matters affecting the company. These rights are exercised through resolutions passed at general meetings, with various mechanisms in place to ensure that fairness, transparency, and effective participation in the decision-making process. So, they have to identify that there's been a lot of fairness and there has been the issue of, transparency when these voting rights have gone through. Next, we're looking at 3.3, which is to analyze minority shareholder protection. So the Companies Act does give all shareholders basic rights, but rights and protections afforded to minority shareholders under the Companies Act are very limited and do not deal with the multitude of common situations which apply in companies. The most common problem for minority shareholders in a private company is where the directors of the company are the majority shareholders or appointed by them. In this situation, the minority shareholders have virtually no say or on decision making and very limited visibility on financial information. The majority shareholders can easily manipulate things to their advantage. So minority shareholders protection refers to the legal frameworks and mechanisms designed to protect the rights and interests of minority shareholders in a company, particularly in situations where they have been more vulnerable to oppression, unfair treatment, or abuse by majority shareholders or company management. Here's an analysis of minority shareholder protection. So as I mentioned, minority shareholders don't have as much rights as enhanced, majority shareholders. And the distinction between minority and majority shareholders is vital because it significantly impacts a shareholder's influence of the company's decision-making process. As we said, minority shareholders who hold more than 50% of the company's shares have the power to control the ordinary resolution. On the other hand, minority shareholders, despite having a smaller proportion of shares, still possess significant rights under English law. They can challenge decisions that they believe are unfair or prejudicial and vote on certain matters such as the election or removal of directors. So legal framework. As we mentioned, many jurisdictions have statutory provisions and legal frameworks that provide specific protection for minority shareholders. These provisions may be enshrined in company law, securities regulations, or corporate governance. These legal frameworks aim to ensure fair treatment, equality of rights, and equitable treatment of shareholders regardless of their ownership stake in the company. As we mentioned earlier, it's really important in regards to that. Rights of information and inspection. Minority shareholders typically have the right to access information about the company, including financial reports, annual reports, minutes of general meetings, and other relevant documents. This enables minority shareholders to monitor the company's affairs, assess its financial health, and exercise their rights effectively. Protection against oppression. Minority shareholders are entitled to protection against oppression or unfair treatment by majority shareholders or company directors. Legal remedies may be available to minority shareholders if they can demonstrate that their rights have been unfairly prejudiced, oppressed, or disregarded by the majority, such as dilution of their shareholding, exclusion from decision-making processes, or division of corporate opportunities. Minority veto rights. In some cases, minority shareholders may have veto rights over certain major decisions, such as changes to the company's articles of association, significant transactions, or mergers and acquisitions. These veto rights help protect minority interests and prevent decisions that may be prejudicial to minority shareholders. Derivative actions. Minority shareholders have the right to bring legal action against the company or its directors on behalf of the company, known as derivative actions, if they believe that the company's interests have been harmed by wrongful conduct or breaches of fiduciary duty. This allows minority shareholders to hold company management accountability for any wrongdoing or mismanagement that may harm the company or its shareholders. Exit rights and remedies. So minority shareholders may have exit rights or remedies available to them if they are dissatisfied with the company's management or direction. These exit rights may include the right to sell their shares back to the company or at a fair price, seek judicial remedies for oppression or unfair prejudice, or pursue alternative disputes resolution mechanisms to resolve conflicts with majority shareholders or company management. There are also risks for minority shareholders. So without a shareholder agreement or an amended Articles of Association, situations that can and do arise regularly with private UK limited companies include directors only act in their own interests. So this may include paying themselves very significant salaries rather than declaring dividends. Lack of information. So this is without regular, meaningful information. A minority shareholder will not know what's really going on with the company. Value of shares. There can be situations where minority shareholders do not get fair value for their shares, especially if they're employee shareholders. A disposal of company assets or the company in a way which benefits the majority shareholder. Financial manipulation, for example, excessive or unusual borrowing or entering into contracts which are onerous or benefit the majority shareholder in some manner. So there are ways to protect a minority shareholder. And firstly, agreeing to deal with issues later rarely works on minority shareholders' advantage. If the majority shareholder is not prepared to consider your concerns or anything, and ought to be a serious red flag for you, whether you are investing a significant amount. The usual ways to protect yourself as a minority shareholder and enhance any sort of protection would be in terms of veto rights or key decisions and board representation. If you have fairly significant minority shareholding, or there are other minority shareholders who agree with you, push for a place on the board of directors to protect yourself. Enhanced rights to information, so make sure proper and regular availability of information about financial health and performance is available to you. Another way is dividends, steps to prevent directors rewarding themselves and deliberately not paying dividends, a clear policy on payment of dividends and prevention of profits reducing tactics, valuation of shares known as tag-along rights, but also favourable and fair good leave, bad leave provisions, potentially as a formula to fairly value your shares on a buyout, and dispute resolution mechanisms, so a fair process, which means you are not left only with very difficult unfair prejudice or derivative claims, which potentially also include arbitration or mediation. In conclusion, to looking at the issue around minority shareholders protection measures are essential for ensuring, again, fairness, transparency and accountability in corporate governance. By providing a legal frame, safeguards and remedies, these measures help safeguard the rights and interests of minority shareholders and promote confidence in the integrity and fairness of the company's operation. So these are some of the references for learning outcome today, which we've done learning outcome 3. So there's lots of references you can refer to help you with the assignment. So we've got the first one by Amor, the Anatomy of Corporate Law, a comparative and functional approach. We've got Barnett, Corporate Governance and Accountability. Davies, Principles of Modern Company Law. Davies again, Business Organizations and Management. Ethregul, Minority Shareholding Protection in Company Law. Hansman, The End of History for Corporate Law. Hilliard, Directors' Duties and Liabilities, and then Kershaw, Company Law in Context. We've also got Lipton, The New Shareholder Activism. Mead, The Modern Law of Directors' Duties. Ramsey, Corporate Governance and Shareholder Activism. Reesberg, Corporate Governance and Directors' Responsibilities. Seeley, Cases and Materials in Company Law. Singh H, Minority Shareholding Protection under UK Company Law, and Thompson, Company Law and Law of Incorporated Business Entities. Now, these will help you towards extra reading, additional reading, to help you with your assignment when it comes to it. Also, please refer to Moodle for any sort of ebooks or journals for additional reading. Any further reading will be on Moodle. If you've got any questions, please email learnerwork@ukvarsity.org.uk. So we've finished learning outcome 3 now, and the next learning outcome will be learning outcome 4. Thank you for attending today's session. Thank you.